Last week, the United States carried out an unprecedented strike against a vessel suspected of narcotics trafficking in the Caribbean, destroying the vessel and reportedly killing all 11 people on board. The action is deeply troubling, not only because it lacks justification under domestic or international law and likely violates a number of clear prohibitions on murder and extrajudicial killing. It also raises highly concerning questions about the process followed within the U.S. government. How and by whom was this strike authorized? Why was it carried out by U.S. armed forces? And what kind of accountability or pushback might we see from Congress, in courts, or within the government itself? This is the Just Security Podcast. I'm your host, co-editor-in-chief, Tess Bridgeman. Joining me today to unpack the attack, the limited justifications the administration has put forward to date, and what to expect from here are two leading experts on the use of force and both domestic and international law, Rebecca Ingber and Brian Finucane. Rebecca Ingber is a professor at Cardoso Law School and a senior fellow at the Reese Center on Law and Security at NYU School of Law. She previously served in the legal advisor's office at the U.S. State Department, including as counselor on international law. Brian Finucane is a senior advisor at the International Crisis Group and is also a former attorney in the Office of the Legal Advisor at the State Department, where he also focused on the legal framework for U.S. counterterrorism operations and the use of military force. He recently published an article in Just Security on this strike titled Legal Issues Raised by Lethal U.S. Military Attack in the Caribbean. Hi, Beck. Hi, Brian. Welcome to the Just Security Podcast. Wish we were talking about something different today, but there is a lot to unpack about the recent strike on a vessel in the Caribbean by the U.S. military. And I thought a good way to get us started before we get into any of the weeds, because there really is a big picture that it would be helpful to be focused on here. Could I get just a few thoughts from each of you about how you're thinking about this strike as a whole? What's the big picture that you have in mind before we dive into the law? Brian, do you want to go ahead?
Sure. I mean, it's easy for the American public and some members of Congress, perhaps, to simply chalk this up as another targeted strike on terrorists. And the U.S. has been doing since 9/11, 2 decades plus practice of doing drone strikes on designated terrorists around the world. But that is not what happened here at all. Okay. This is not an operation in the context of an ongoing armed conflict with some group that previously attacked the United States. We have a word in the English language for the premeditated killing of someone outside of an armed conflict, and that word is murder. The Trump administration has not even argued, much less established, that the United States is engaged in an armed conflict governed by the law of war, which would allow for the premeditated lethal targeting of individuals. It has not argued that the individuals struck in this attack were somehow lawful military targets under the law of war. That is what makes this situation so much different from all the other targeted killings and uses of force we've discussed, often controversially, but over the last 2+ decades of the war on terror.
Yeah, thank you. That's really helpful, big picture. And Beck, I would love to hear if you have similar thoughts or anything else that you might add.
Yeah, I agree entirely with Brian. You're not going to be surprised to hear. I think that politically, Trump is trying to distract us with this wartime language. I think we saw it in other contexts as well. I think there's a sense on both the right and the left. On the right, perhaps a sense that, well, it's a good thing for the president to be able to shoot up some bad guys. And on the left, there's a feeling like, well, we've criticized presidential overreach before, and that's come to naught. Well, how is this any different? And I think there's a special task for those of us who both have been critics of aggrandized presidential power in the past, and yet who understand that this is categorically distinct from everything that we've seen before. Perhaps it's the apotheosis of everything we've warned about. What might these powers look like in the hands of a tyrant? But in this case, I think the lesson is just clear about what's happening. The president is saying that he is killing people for suspected crimes. It's murder. It's extrajudicial killing. This is illegal under any standard of law. And he's saying he's going to keep doing it.
Yeah, murder, extrajudicial killing. And I think it's helpful also that we think about the upshot here. If he can do it here, he can do it anywhere. There's nothing particularly salient about the high seas with that with the fact pattern that we're about to get into. So the upshot is the president has claimed the authority to engage in premeditated murder of suspected criminals without due process, trial, or even an attempt to arrest or interdict. And the military has carried out that order. So we can unpack all of that. But first, let's do briefly the facts of what actually happened in a little bit more detail for folks. And Brian, you wrote a great piece for Just Security. You've both been, speaking and commenting publicly about this, but I wonder if you could get us started with just a little bit of the background, because this didn't start with just the September 2nd strike. There's been a bit of a buildup. Can you give us, in your view, kind of the salient data points for what led to that, the vessel strike on the 2nd?
So President Trump has been using military force against narcos in Latin America since his first term. When a public health official who happened to be wearing a uniform suggested targeting cartels in Mexico. Trump did not understand that this individual was not a Pentagon military officer, and so but the idea sort of lodged in his brain. And we've seen considerable discussion on various proposals to treat the war on drugs more like a real war the last few years. And so there's been building momentum for military action in Latin America against, drug trafficking organizations. In February, the administration designated a number of Latin American criminal groups as foreign terrorist organizations. This was unprecedented and frankly, inappropriate use of that authority. And figures in the administration started talking about this being somehow permission to use lethal force against these entities. It's not. We can get into that in a moment. But there's been building momentum for the use of military force in Latin America. In the last several weeks, we've seen a buildup of U.S. Military equipment and personnel in the region. Reportedly, this is being driven by Secretary of State Rubio, and it represents saber rattling towards the Maduro government in Venezuela. So we've seen multiple destroyers, Marines, thousands of sailors, most recently the deployment of F-35 fighters to seen reports of armed MQ-9 Reapers, airfield in western Puerto Rico. Those may be particularly relevant for discussion of this strike. And so we've seen this build up. On the one hand, it's intended to put pressure on Maduro. And then we've also been hearing rumblings in the press, some great reporting in the New York Times with Charlie Savage about potential authorizations that have been issued or directives issued by the White House for military action in the Caribbean around Venezuela. And then finally on September 2nd, last week, an Oval Office appearance in which the president also discussed sending troops into Chicago, almost in an offhand fashion, the president mentioned that there had been a strike that in the Caribbean on a vessel. And then shortly after this Oval Office appearance, there was a tweet by Secretary of State Rubio describing the action. And then the president posted a longer message on his social media platform with a video of the explosion. And there's claims that 11 people were killed, variously described as narco terrorists, allegedly in international waters. But it's important to emphasize that the administration has not proffered facts to substantiate any of these various claims. So we don't have a lot of hard information we're operating off of here, though I think mostly everybody assumes that there was actually a military action and people were killed. But beyond that, we don't know who it was, where exactly it happened, what was on the boat, where it was going. Those are all unknowns as far as I can tell.
Right. And importantly, the administration hasn't been working to clear that up in the almost week that has passed since. So they did file what's known as a 48-hour War Powers Report. And all of us, when we worked in government, have worked on those reports. We're very familiar with their contents. They do have to be filed within 48 hours of the incident in question. So they're not generally long and incredibly detailed documents, but they do contain generally enough relevant information for Congress to start to do its job and for the American public to understand what's going on. But of course, that's not the only way the public's informed or Congress is informed about actions like this. There are usually statements from the podium, press briefings, releases, et cetera. We've seen a remarkable dearth of that in this case. Which itself is a red flag that there may be different stories inside the administration about what actually happened and who was actually targeted. But worth noting about the War Powers Resolution report, these are required when troops are introduced into hostilities or imminent involvement in hostilities. And they have to identify the purpose of the activity, a couple other things, their basis in law, their expected scope and duration. And this report did not mention the actual target in any kind of identifiable way. And I'll just read the words. It references a vessel that was assessed to be affiliated with a designated terrorist organization and to be engaged in illicit drug trafficking activities. So what do we make of this in terms of the facts of what we know about who was targeted in this operation?
So I'll dive in here. I mean, often we get these reports when we're on the outside, and those of us who've spent time in the inside, can sometimes sort of decipher a little bit more than might be clear from the language. And so we can go through and try to figure out and pull apart what the government's legal position might be from these reports. And so going through this, we've got words that have, it's almost as if they took prior reports. And I think Brian at one point said something about legal Mad Libs. It's like they took some templates or took some words from prior reports and threw them at the mat, along with some facts that they were willing to give us about this event, to try to claim some legal authority. But it doesn't hold together. And so we've got language about the inability or unwillingness of some states in the region to address the continuing threat. Well, what is that? That sounds to us in language that people might think of as the unwilling or unable theory of when a state can use force in another state's territory to address a non-state actor. So that suggests they are making some kind of claim here about the ability to use force against what they consider to be non-state actors in a state's territory. That means they think that it implicates 2.4, the prohibition on the UN on the use of force in the UN Charter. And just to back up, what does that prohibition say? Well, it says that states can't use force against other states in their territory, against their political independence, et cetera, or in any other way outside the purposes of the United Nations. And the only narrow exceptions to the prohibition on the use of force are a UN Security Council resolution authorizing force or the use of force in self-defense. And so when we see language about self-defense, and in another statement we saw collective self-defense, which also comes from that same exception, that suggests that the US government is trying to suggest a legal theory that stands in wartime authorities. It suggests it thinks 2.4 was implicated, which suggests it thinks that it is using force against another state, or in another state's territory. In this case, we know that this was a strike on a boat at sea. And so they are trying to create with this language a legal framework that sounds in wartime authorities. The irony here is that these are very, very clear authorities that and prohibitions that the United States government has long signed on to, and nothing in any of these authorities or prohibitions makes what they did legal. We did not suffer an armed attack. We are not responding to an actual armed attack or an imminent armed attack. And even if we were, we would still be guided by the laws of armed conflict, the laws governing the conduct of hostilities, in which case we would be obligated to distinguish between combatants and civilians. And it is quite clear that everyone on that boat is not being alleged to be combatants. These are civilians. And so if the law of armed conflict were to apply to this scenario, this would be a war crime.
That's right. And let's come back to the rest of the kind of process of what happened in a minute, because this is an important point that we should stick with for a minute. The unable or unwilling language, I think, pricked all of our ears for the reason that you're just describing, Beck. This is the language that the executive branch uses when they're going to use force in another state's territory without its consent, which is not what happened here, right? The one thing we're all clear on is that this boat was in international waters. It was not in Venezuelan territory. There's a lot that we don't know about who was on the boat. Exactly where it originated is something that's just now being reported in the Venezuelan press. We'll see how that reporting bears out. But we'd also know that the Venezuelan government immediately sort of disclaimed any relationship with this incident. I think they even alleged that it was AI that had made up the video that President Trump posted. So it's very clear that there's at least an intent to disavow a state nexus and no information indicating that there might have been one. So unable or unwilling, right, that invocation of those words It's either totally nonsensical war powers Mad Libs, to use Brian's phrase again in this case, right? Or it's presaging some sort of broader campaign that is intended to take place within the territory of non-consenting third states. Whether it's Venezuela or others in the region should be equally alarming because, as you just said, Beck, there's no one that's conducted an armed attack on the United States or threatened one. We're not in an armed conflict with any non-state or state actors in the region. There's simply no basis in international law for this action to have taken place. So, taking that as our starting point, there's no basis in international law to have used force. Let's talk about what in international law prohibits these actions, aside from the fact that force may only be used in self-defense. There's two paradigms that you're referencing, Beck, just now, and maybe we can take those each in turn. So if we were in an armed conflict setting, right, and the law of armed conflict applied, as Beck just said, you can't target civilians. These were clearly not enemy fighters. They were not combatants. So that one is already clear. But say we're not in an armed conflict, which I think the three of us agree on.
Yeah, if I could just stop on the first paradigm, and to be clear, for the United States to be in an armed conflict, and setting aside the question of whether it might in the future be an armed conflict with the Venezuelan state, for it to be in an armed conflict with a drug gang, that gang would have to be constituted in such a way that you characterize as an organized armed group, right? It would have to have a certain structure, certain military capabilities, right? It's not the fact that every criminal organization on earth is an entity that the U.S. can be in an armed conflict with, or what we colloquially refer to as war. So in the absence of an organized armed group in which the U.S. is, in hostilities with, you can't characterize this as an armed conflict, and you can't use the permissive structure of armed conflict or the law of armed conflict to govern any such hostilities. And that's where I was talking to my crisis group colleagues. They have some real doubts as to whether you could characterize, for example, Tren de Aragua as an organized armed group, such that the U.S. could actually be in an armed conflict with it. Again, we don't actually know which group it is because the War Powers letter doesn't tell us.
Right. And let's tease out a little bit more the requirements for being in an armed conflict, just for removal of doubt. There has to be an organized armed group, has to have certain command structure, right, capable of following the rules of war, even if they don't do it in the instance at issue. There also has to be a certain level of violence that is protracted, right? And this comes from the Tadic opinion, right, an international criminal law case, but it's more or less crystallized into customary international law, these two prongs of an organized armed group and sustained protracted fighting in a way
with the
that
United States, right? It's not just with anybody.
right,
They have
right,
to have been engaged in protracted hostilities with us.
right. And the United States government has long accepted, right, this sort of two-pronged test for when an armed conflict exists with non-state actors. So that's an important kind of background principle here because the administration is trying to fuzz this up. And both of you have written about the Alien Enemies Act proclamation that the Trump administration issued purporting to claim some sort of hybrid warfare, right? Irregular warfare with Tren de Aragua, which itself is trying to make out some sort of armed conflict-based theory, which would be needed to invoke the Alien Enemies Act at all. But seeing as the facts just don't add up on this armed conflict idea that they're sort of motioning at without fully embracing full force, at least yet, we're not in an armed conflict paradigm. And where does that leave us, right? The normal peacetime rules apply, and that includes international human rights law. And so I think it's helpful to talk about what is this term that we all kind of threw around when we were framing this whole incident, extrajudicial killing. What is that? Where does it come from? And just to kind of get us started here, right? That's a term that's used in international human rights law, and the United States is party to a number of relevant treaties. There's also customary international law that prohibits depriving someone of their life arbitrarily. What does that mean? It means that in armed conflict and in cases where absolutely necessary in self-defense, right, someone can be deprived of their life by a government, but outside of those two relatively limited exceptions, killing someone without process, killing someone arbitrarily is murder, is extrajudicial killing. And I was struck that there is really no room for doubt that that is the case in terms of whether there was process here because of Secretary of State Rubio's own statements, right, where he says, we could have interdicted the vessel. We could have followed normal process here. We did not. On Trump's orders, we chose to blow it up. So would welcome your kind of thoughts on anything that is striking to you or that we should, tease out further about international human rights law and how it applies here.
Well, I would just say generally that those statement by Rubio undercuts any self-defense argument across a number of different domains of law, right? It's hard to argue that the use of military force here was necessary. The purposes, if you're looking at this through the use ad bellum, Article 2.4, Article 2.1, self-defense paradigm. It's hard to argue that it was somehow absolutely necessary under a human rights law paradigm. And as we might get to in a few minutes, it's hard to invoke self-defense as an affirmative defense for domestic criminal liability purposes as well.
Yep. Before we get into the domestic law, and Beck, maybe you can shed light on this one. Why is the administration trying to make a self-defense argument here, given the lack of a viable theory? What do you think might be motivating that?
So I think that's a great question. I think there's a political and a legal dimension to it. We were just talking about human rights law, both as a matter of international law and as a matter of domestic law, murder is prohibited. And when we're talking about the use of force, the use of state force against individuals, where truly the scenario at hand is something about the state as against human beings. It's not truly one of state to state relations, right? But rather something about the state versus individuals as people. Human rights is the right framework. And as a matter of domestic law, the summary execution is prohibited under various murder statutes. And so there are very limited exceptions to that prohibition on killing people. And one of them is in the context of armed conflict. And that's true both as a matter of international law and as a matter of domestic law. And so while, yes, I think politically the Trump administration is trying to use wartime language because they're trying to fuzzy up what's going on here and to suggest that this is just of a piece with what came before, nothing to see here. We're just going after bad guys, just like every other president before me over the last 25 years. I think that's what's going on politically, but legally, in order to get out of these frameworks where this is just a clear prohibition, in order to get around this as a matter of international human rights law, in order to get around the domestic statutes prohibiting murder, you have to claim that there is some what an OLC memo called a public authority exception, but an exception for lawful killing under the laws of armed conflict. And the idea there is that domestic law somehow permits the president and people acting under his orders to use force to kill in very narrow circumstances if that force is permitted under the laws of armed conflict. And that is true as a matter of international law, but it's also the way they get around those domestic statutes. And so that is why, as a legal matter, they might be trying to claim this framework, even though it is completely unviable in these circumstances.
Yeah, that's all exactly right, that it is unviable under these circumstances, but it is
Non-viable.
the only way to get around it, to get around the law. So let's unpack those laws a little bit more now. So just like we were talking about with international law, there's both no affirmative source of authority, and there are also actual prohibitions, right, that appear to have been violated here. And I think we could say the same, unfortunately, about domestic law. There's no affirmative source of authority. There's no authorization for military force from Congress, certainly, nor did the administration even claim that there is one that might be applicable in this situation. I would argue there's also no Article 2 authority, but that's what the administration did rely on in its War Powers report. So maybe we can talk about that for a minute before we get into what domestic laws may actually have been violated here. And I don't know if either of you would like to kick us off with the Article 2 argument.
I'm sure both of us have much to say on that subject. Becca and I both written at length about this, but I will start off by making a point that I heard you make in the past, Tess, which is that the over the recent decades, the U.S. executive branch has crafted a very permissive, very capacious doctrine about when the president may use force in the absence of prior congressional authorization. It turns on a two-part test that is well known, likely to many people, which is that the prong one, whether the contemplated use of force would advance a sufficiently important national interest, and prong two, whether the contemplated military action would amount to war in the constitutional sense, such that Congress would have to authorize it. The key point here is that this is the executive branch's test. It's not been endorsed by the courts, not been endorsed by Congress. It does not appear in the text of the Constitution itself. And for background, there's a reason that the framers of the Constitution gave the bulk of the war powers to Congress and did not leave it to the whims of one man. Going to war is supposed to be hard, it's supposed to be an act of collective deliberation and debate, open to the public, okay? And that's not what happened here. So the executive branch will tell you, and many I'm sure lawyers in the administration would argue this is consistent in terms of past invocations of Article 2 by the executive. I would contest that for a number of reasons, but that would be sort of the argument. Now, in terms of I'll turn over to Beck to see her thoughts on this before we get into the criminal statutes.
Yeah, no, I agree with that entirely. I think that this lays bare the problems with the not war theory of presidential authority. So as you know, as Brian pointed out, the Constitution gives Congress the power to declare war, and the idea that most people have when they read those words is that Congress is supposed to decide whether we go to war. And as we know, over the years, that the president has seized more and more power to do so unilaterally. And under a long line of OLC presidents, he does so when it's not war in the constitutional sense, and war in the constitutional sense has this high bar. I think that there's one thing that I want to just add to that that's I think interesting about this history is that there's actually been a distinction until about 2018 between Republican and Democrat OLCs, if I can call them that. I know that the lawyers in those offices would quibble with that partisan assessment, but it actually was a line of OLCs under Democrat presidents that started the war in the constitutional sense that elucidated that theory, starting with a 1994 decision, I believe, by Walter Dellinger, that was attempting at the time, I think, to constrain the president's use of unilateral force. And so they crafted a theory in an effort to say, okay, this is what's come before, this is how we're going to create some constraints around it, and we're going to say that this particular use of force has to meet all of these different factors, and because it does so, it's not war in the constitutional sense. And that has been built upon and built upon over the years to become more and more attenuated and permissive of more and more uses of force that frankly start to look a lot like war. There is another theory, another line of legal theories, which I think actually is a little bit closer to the framers' idea, which was that the president can use force to repel attacks, right? Mm-hmm. And what those OLCs have drawn from that is that the president can use force in self-defense. And that becomes, as we know, if we're drawing from what the US government's position has been on self-defense in the international law space, that has become a lot broader than repelling attacks in the kind of immediate sense that I think the framers had in mind. But if we go back to that concept as a constraint, so we're not just talking about not war in the constitutional sense, but we're also saying there has to be some requirement of self-defense. I think that gives us a little bit more constraint here, and that is closer in line with what I think Americans generally would think the president's powers might be, which is that he can't just use force willy-nilly, but there has to, at least at a minimum, be some sense that he's doing so either through a congressional authorization or some sort of other authorization, or truly necessary to defend the nation in some kind of immediate sense.
And I would just add to that, I have argued, I think Marty Lederman has written as well, that Article 2.4 of the UN Charter binds the United States not just as a matter of treaty law, but by virtue of the Take Care Clause, it also binds the president as a matter of domestic law. The president has an obligation to take care that the laws are faithfully executed, and those laws include treaties as well as statutes. And so if there's so that should also serve as a constraint on unilateral presidential war making.
Yeah, so we have this Article 2 test that is exactly as you both described, broader and broader in terms of when it permits the president to use force without congressional authorization over the decades, which makes Congress's remit narrower and narrower. right? Farther and farther from the core kind of self-defense idea that the framers would have envisioned, and that, as Brian notes, they envisioned for a reason, because the idea was that this power shouldn't be in the hands of one man. And certainly, if you look at the War Powers Resolution notifications from the first couple of decades, there is generally a claim of some sort of self-defense, right? That we've gotten farther and farther from, as this test has evolved to include other kinds of national interests, as the OLC test calls them, right? Which can be, at this point, essentially anything the president articulates. And less amounts to war in the constitutional sense. But I would say, just as one note of caution, even if we're talking about building on the executive branch's own precedents, and I'm glad you laid out, Brian, the caveat that I always like to give, that this is only the executive branch's view and not Congress's view, and need not be the courts or the court of public opinion for that matter. But even on the executive branch's own view, if this was the opening salvo of a campaign, and they know that, right? Because there has been some sort of internal memo authorizing lethal force against FTOs. Now, we don't know if there's any sort of tempo or cadence to these strikes anticipated, right? We don't know if there are battle plans, concepts of operations, et cetera. But the fact that we don't know that, right, means that it is possible that that is anticipated, and that this would, in fact, even under the executive branch's own test, amount to war in the constitutional sense, because this is supposed to be judged ex ante, right, based on the anticipated nature, scope, and duration of the activity. So I think we should just put an asterisk there and leave that one open until we see how this evolves further, which also, of course, has implications under the War Powers Resolution 60-day clock, which requires termination of the use of armed forces in hostilities after 60 days, unless it's been authorized by the Congress. So putting an
that's
asterisk on Article 2 and the war powers.
that's all exactly right. And I just would further, if the administration actually anticipates hostilities with Venezuela itself, that war in the constitutional sense prong should be doing a lot more work.
100%. Yep.
Yeah,
so we'll come back on that, the three of us. I suspect we're all having the "I told you so" moment we wish we weren't having right now about the scope of Article 2 power and the use of force context, but didn't anticipate it would play out in exactly this way, where you have such a clear arbitrary deprivation of civilian life. So let's get into that. So the domestic laws that may be violated here. Maybe we could start, either of you, with one that folks may not be as familiar with, but is actually really important inside the executive branch, the assassination ban. If either of you would like to give us the Cliff Notes version.
I'm actually going to let Brian take that one, because I've never fully understood where the U.S. government thinks the parameters are on that one.
So what's referred to as the assassination ban is enshrined in Executive Order 12333. So that is an executive order, not a statute. And it bars U.S. government employees from engaging in assassination. And that term has been interpreted over the decades by the executive branch. And this is my spiel here is based on publicly released positions and analysis. Been interpreted to mean killings that would be unlawful, in the sense that they would not be permitted either as an action in self-defense, okay, and self-defense both in sort of international law terms, but also in the criminal law sense. But also killings that would be permissible under the law of war would not constitute assassination. So if you're in an armed conflict context, okay, the killing of an enemy combatant, okay, or someone killed as lawful collateral damage would not constitute an assassination. And so outside the context of an armed conflict, the only real way you can get around the assassination ban would be able to establish that the action was in self-defense. So that may be another thing that the invocation of self-defense is getting at here, is gesturing towards, well, we have this exception to the assassination ban as well. I don't think it holds up for all the reasons we've laid out about why we don't think this constitutes self-defense, no matter what the paradigm is. But yeah, so there's the assassination ban, and then we have these criminal statutes.
Yeah,
go ahead.
I'm happy to jump in on those. So yeah, so that's all that I've understood as well, and I'll get to why I sort of jokingly said that I didn't necessarily understand the government's approach to it, but there are a number of criminal statutes which, of course, as you'll be surprised to hear, prohibit murder. So and in particular, as relevant to these purposes here, the U.S. Criminal Code Title 18, Section 1111B makes it a felony to commit murder, and it's murder is defined as the unlawful killing of a human being with malice aforethought, and that is applicable within the special maritime and territorial jurisdiction of the United States, which is defined to include the high seas. That's under 18 U.S.C. Section 7. And 18 U.S.C. Section 956 makes it a felony to conspire within the United States to commit at any place outside the United States an act that would constitute the offense of murder if committed in the special maritime and territorial jurisdiction of the United States. If any of the conspirators commits an act within the jurisdiction of the United States to affect any object of the conspiracy.
So like ordering the operation.
Right. So presumably most, if not all, of the actions that went into ordering and discussing and planning the operation would fall within that statute. The reason, and we've also got the UCMJ, the Article 118 of the Uniform Code of Military Justice, which at Section 918 prohibits the unlawful killing done without justification or excuse. So we've got a number of criminal statutes. We've got the assassination ban. And again, the reason that the administration is trying to paint this in wartime terms is because they believe that calling it an exception, that calling it an armed conflict, saying that they were doing so in self-defense, would somehow get them out of these statutes. Either they're doing it for those reasons or they don't realize that that would be their argument.
So this is where those of us who have practiced in government, but plenty of folks who haven't, are really scratching our heads because these statutes are pretty clear. There is a very strong case on the facts as we know them now, again, without the executive branch having rushed out to add more information to what the public knows. Based on what they have said, these killings were ordered by the President of the United States. Even though it was possible to simply interdict the boat, they have claimed no attack or imminent attack on the United States. And there's, as you've mentioned a couple times back, no plausible self-defense argument here. So a couple of kind of head scratchers. One, why did anyone in DOD go along with this? It boggles the mind that at least the folks I know in uniform would have unquestioningly obeyed an order like this. So what story was being told internally that made someone say, yes, I'll pull the trigger, right? What facts were people presented with? What legal sign-offs did they think had been received? Right? These are questions we don't know the answer to yet. And kind of the flip side of this is on the back end, accountability. Should people in Southcom be getting lawyers? Are there folks within DOD who are trying to put the brakes on further operations because it's so clear that there ought to be criminal accountability here? I'm not saying that this DOJ is going to start prosecuting people. I'm saying it sure looks like under both domestic and international law, there are criminal violations at issue. And so at some point there could be accountability, whether in the United States or abroad, for some of these actions. So I would just love to hear any of your reflections on what you think may have been going on internally, and whether you think there is any prospect for accountability, whether that's criminal accountability at this stage, political accountability, accountability from Congress, right? Or simply, internal bureaucratic accountability, if we want to call it that, that might slow the gears of future operations like this one, now that folks are aware of what actually happened, right? Whatever was said on paper, whatever was communicated internally, whatever assessment someone was reading before this happened, now we've actually seen it happen, right? So it's those facts that have to be reckoned with.
So the one thing I would say that I think actually connects the question of political accountability to the question of what was happening on the inside is that typically these conversations at the what I'd call the use ad bellum level, the question of whether or not the president can use force against a particular actor in sort of the macro sense or in a particular territory, in a particular context, those are typically made at a very high level. And those would involve lawyers in an interagency process run by the NSC. Tess, you would have run many of those meetings. I participated in that lawyers group, as did Brian. Those meetings were happening regularly at all times when I was in the government, and I served under both Republican and Democratic administrations at multiple times. And those would be where the conversations at that level of would be happening. And the questions for the operators at the sort of line level, right? The line soldier. Typically there would be, first of all, there would be a JAG involved in those kinds of conversations, but also that their focus is going to be on the law of armed conflict, what I think of as sort of the micro question. So the use of force is the macro question, the law of armed conflict is the micro question. And certainly I think that we can still expect, and we would expect, soldiers on the ground to be prepared, to be well trained, not to violate obvious manifest prohibitions in the laws of armed conflict, like you can't torture someone, you can't kill an obvious civilian. When questions are being made at a high level about use of force against a particular group and whether or not that group can even be in an armed conflict with the United States and whether or not therefore their members are combatants, I think that is possibly too much to ask people on the ground to be deciding in that moment. And that is why we have this high level lawyers process. And it's why I think the absence of that is so concerning. People have said it time and again that there are no guardrails in this administration. And this again goes to the question of accountability. If there aren't people who feel it, who even understand these concepts, who feel any shame in making arguments that have no legal viability, who aren't interacting with their counterparts on the Hill to explain and to feel pushback and again to feel like they'd be going back to a legal community where they would feel shame for having proposed such a thing. Those are real guardrails that work under normal administrations that are completely missing here.
Yeah, and so to kind of add a little bit more context to what you were just saying, Beck, about where use ad bellum decisions are made, right? Is there authority or a justification under international law, under domestic law to use force in the first instance? Those are headquarters decisions. Those are situation room decisions, right, that are made by the president, but on the advice of his entire National Security Council, right? Usually after a series of meetings, written memos that would include a legal review coordinated by the National Security Council lawyers, but it would include the senior most political and career officials from the Department of State, the Department of Defense, right, the intelligence community, the Department of Justice, and they're going to provide, whether it's the best view of the law or a plausible reading of the law that has changed across administrations, but they're going to, in a situation like this, right, not result in a memo that says, yes, Mr. President, you can do this, right? So the idea that there would even be a legal memo that has to explain why this is unlawful, to I think your second point, Beck.
That would be enough of a constraint in a circumstance like this where it is absolutely an insane theory.
That's right. That's right. Where, the concept of operations to begin with, or the memo presenting this theory that why don't we start doing this, would have been in the trash bin well before it
People
got
have to put their names on these things, right? OLC memoranda, for example, are signed. There's a reason for that. That is some version of accountability.
So do you think that there might be an OLC memorandum laying around somewhere in this case, right? Is there, unfortunately, in our nation's recent history, we have seen OLC memos purporting to, legalize torture and extrajudicial killing. Well, at least torture and enforced disappearance, I should say. And, the idea that, as you were just saying, Beck, to an operator, someone above me in the chain of command, or someone, in Washington with more authority than I have, has said this is lawful, is unfortunately one that, it wouldn't be unprecedented. Here, I think it's very difficult to say there isn't at least a category change insofar as all these predicate facts that we've been talking about are so clearly not met, right? There's not an armed conflict. There's no valid invocation of self-defense here. So it's really hard to see how that memo writes in this case. But say you found a political lawyer right, who was willing to put their name on it in the White House counsel's office, in OLC, in the AG's office, maybe somewhere in the Department of Defense, right? Um, should that be sufficient, or what is the operator's duty in that case? Do they get this order and say, no, this actually falls into that very narrow category that I've been trained, right? I was hoping I'd never come across one of these, but it sure looks manifestly unlawful. So I have a duty to at least ask, right? Is this colorable? Um, what do we think what do we think happened at the operational level here, or what should have happened in a case like this?
Well, I have, based on some conversations I've had in recent weeks, I have the sense that there was interagency discussion, not just about the targeting of narcos or criminal organizations writ large, but specifically on targeting vessels. Okay.
Mm.
Which seems to increase the likelihood that there might be some sort of either interagency legal guidance or OLC top cover provided. Okay. And if OLC wrote some memo making the case that this was lawful self-defense for purposes of international law, the assassination ban, and as an exception to these various murder statutes, it might be very hard for JAG at Southcom or elsewhere to push back against that. Very hard for operators to push back against that, even if you and I might regard the targeting of apparent civilians as manifestly unlawful. There might be an argument that, well, they don't qualify as civilians for these purposes, or they pose an imminent threat to the United States, then therefore the killing is not unlawful. So that is one scenario. We don't know this. This is to some extent speculative, but it would make sense, based on the past practice you referred to earlier about the torture memos, where the CIA sought top cover from OLC. So I think, in terms of accountability, I think it's important that Congress and political leaders in this country send a signal that no, intentionally killing civilians this way is manifestly unlawful, and we will do our best to hold you accountable, if not today, then down the road.
Congress should be asking for whatever memo may exist, whether it's in OLC, the AG's office, DOD, elsewhere, and trying to figure out also operationally what's been approved, whether this is in fact just an opening salvo or if there's something more there.
Yeah, can I add to that? I think that it is so incumbent upon people on the outside, and specifically people in Congress, to make it clear that this is patently unlawful and not just shrug it off. There is a move that we have seen made over the years where people expect people inside the executive branch to be the ones who are going to stand up to the president and save us from the president, right? So we can, even by people who vote for the president, we can vote for the president, we can support this legislation, we can confirm his appointees, because we expect that the way this is going to be handled on the inside is that there's going to be guardrails, there's going to be people who are going to stand up to him. Of course, the military would never disobey an unlawful order, etc. And I think that's expecting too much. First of all, the executive branch is being razed to the ground. People are terrified. So that's
Mhm.
A. B, let's just think about the individual soldier, right? Yes, they are required to not, they must not obey a manifestly unlawful order, but they must also obey lawful
Okay,
orders.
that's right.
And they are really caught between a rock and a hard place there. And so if there's any confusion whatsoever, and they know that the order is coming down directly from the president, what do you think they're going to do? And so we, the public, have to participate in making it clear that there is no confusion over what we believe to be lawful and unlawful. And Congress has a role to play in that. They have the role, most important role to play in that.
Yes, 100%, Beck. I couldn't agree more. And I do really feel for folks in uniform who are struggling with this right now after they've seen what just happened. It is not an enviable place to be. And it's a really important point that Congress has the role to play. So I hope we see a lot more from Congress in the week and weeks ahead.
Said, I'll just to jump. I will say that I do think it's important, nevertheless, for people to be worried about what the repercussions might be for their actions, because it will cause them to feel a little bit braver in asking questions and pushing back and find, right? The reason that those OLC memos existed because people were concerned about their own liability, their personal liability. And so people need to be concerned about their personal liability in order to ask for legal opinions. And then those legal opinions, and the other thing I'll add is that, yes, those are examples of extreme overreach, but both of those examples, the memoranda justifying torture and the justification of enforced disappearances, both of those things have been wildly repudiated, not just by the courts, not just by Congress, but by the public at large. And I think that's all, that's all of a piece. So, so there, even though there have been overreaches, there have been backlashes to those overreaches. Those were wildly controversial, and once the public understood what was happening, there was widespread fury about it. And it concerns me that we're not seeing that here.
And the worst thing we can do, in my view, is normalize or be apathetic or negligent in our duty to call attention to that, because it's bad enough where it is. And there's nothing constraining about where it is, right? If this can happen on the high seas, it can happen in Venezuela. If it can happen in Venezuela, it can happen in Florida. If it can happen in Florida, it can happen in Chicago. And there's no limiting principle here on the idea that the president and his administration can label a group terrorists, even if that designation has no legal import in terms of the use of force or otherwise, and then just simply start ordering the killings of those suspected to be affiliated with the groups labeled as terrorists. So that I think should be the really alarming upshot that makes it clear why this can't be normalized.
Exactly. I couldn't agree more, Tess. I would just emphasize that the administration has already been framing migrants generally, as well as domestic political opponents, as terrorists. Okay. And so if the president is invoking this, prerogative to use lethal force in the first instance against terrorists just because his administration so designates them, or because he says they represent some threat, as you said, there's no articulated limiting principle here.
Any more closing thoughts on this conversation that has been very sobering on what happens next, where to go from here?
I just would implore people to pay attention and to care about what's going on. I think there's a little bit of nihilism we're seeing from the areas where we would most likely expect criticism of this kind of an action. There is a collective shrugging of shoulders, and I think it is in part based on the president's successful attempt to paint this as of a piece with everything that's come before. And so I think it's incumbent upon all of us to explain how categorically different it is. And I also think, even if you do think it's of a piece of what came before, those actions, the years after the Al-Qaeda attacks that we call the global war on terror years, the GWAT years, those were wildly controversial actions by the president at the time that received major pushback, and that pushback was successful in many cases. And so while some of the president's claims to aggressive power were entrenched, some of them were pushed back upon. And I think that if that lesson that we can learn from that time is that wherever the president's claims start, that's not where they're going to end. These are just going to expand wildly from here.
Yeah. Any parting thoughts from you, Brian?
I would just say that fatalism about the law and our Constitution is self-fulfilling.
Yes.
We as citizens have a responsibility to ensure that our laws and our Constitution are upheld. And we have a responsibility to put pressure on members of Congress to do their roles. We are living through an Article I crisis. U.S. Congress needs to step up to the plate and do its job.
Couldn't agree more with both of you on those parting thoughts. Thank you for this entire discussion and for all that you are writing, speaking about, to put into practice what you just said about paying attention, making sure we're following these threads, understanding what's going on, and explaining them to those who we hope also participate in making their voices heard. Appreciate having you both on, and we will be following this as it develops. Thanks so much. This episode was hosted by me, Tess Bridgeman, and produced by Maya Neer. Special thanks to Beck Ingber and Brian Finucane, both of whom are members of Just Security's editorial board, for joining us today. You can read all of Just Security's coverage of the strike on the Venezuelan vessel on our website. If you enjoyed this episode, please give us a 5-star rating on Apple Podcasts or wherever you listen.